everyone. The mission of the Wisconsin Ethics Commission is to promote and strengthen the faith and confidence of the people of Wisconsin in their government, support the operation of open and responsible government, preserve the integrity of the government decision-making process, and protect the rights of individuals through the administration of the Wisconsin campaign finance, lobbying, and ethic laws, and through readily available and understandable disclosure of information. Today, our speaker is David Berger, Staff Counsel with the Wisconsin Ethics Commission. He's here to provide a brief presentation on the laws applicable to each of you as state public officials. Thank you, David.
Thank you for the introduction. And thank you for the invitation to speak with you all. I very much appreciate the opportunity to speak with our officials whenever possible to try and give them a better sense of the laws. We often say here at the Ethics Commission, that phrase I'm sure you've all heard, that it's easier to ask for forgiveness than permission. But here with ethics laws and lobbying laws, it's really good to flag these issues ahead of time, talk to your legal counsels for your boards, talk to the Ethics Commission if you have any questions. We can help steer you through somewhat ethically complicated situations. We can flag issues for you. We try to stay away from just saying, no, you can't do that. Usually there is a way to accomplish a certain objective. You just need to be aware of your ethical restrictions. So with that, I like to start our presentations with an old political cartoon. This is from 1858. And as you can see here, Wisconsin is being lampooned in what was at the time the national media, essentially. Because we had just gone through a bit of a scandal. So 1858, those of you who know your history, this is about 10 years into the state's existence. We're on our fifth governor, Governor Coles Bashford. And Governor Bashford had done something a little interesting. He had declined to accept the renomination of his party for another term of office and instead left in 1858. And it turned out that there had been rumors, and then there was actually an investigation that was conducted. And again, you might be able to guess from the timing here, 1858, that was the era of railroad barons. And sure enough, there had been bribes accepted by Governor Coles Bashford and members of his administration as well, in exchange for approval of a land grant to the Milwaukee Lacrosse Railroad Company. And Governor Bashford himself received the largest payoff. It was about $50,000 in stocks and $15,000 in cash, which may not seem like a lot in today's money, but if you calculate it forward to today, it's about $1.5 million that he took in bribes. State legislators and a Supreme Court justice were also caught up in this bribery scandal, receiving about $400,000 all told between all of them. Which again is about 9.7 million in today's money. So it was a pretty huge scandal right at the beginning of Wisconsin statehood. And it was the trigger for some of our very first ethics and lobbying laws. We were the second state in the union to regulate lobbying. We've been doing so ever since. And our ethics of public officials have been regulated since about 1897. Various recodifications through that period. Certainly the 70s was probably the most recent one after the Watergate scandals. So, whenever there's a scandal, typically there is a reaction, some sort of reform or regulation. So a little bit about the commission. So we are a relatively new agency, just created in 2016. I'll talk about the history in just a minute, but the structure of the commission, we do have a partisan structure now. We've got 3 commissioners appointed by one party, 3 commissioners by another party. 2 of our 6 have to be former judges, which is helpful for us to have those trained decision makers. But then we have 4 other political appointees as well, and they're all on 5-year terms. But the way the Ethics Commission is structured, there can never be a partisan action of the commission. Bipartisanship is built into the system. It's required, because we specifically cannot have any action of the commission without at least 4 votes. So you're always going to have to get, at a minimum, 3 people from one side plus 1 of the other. Although actually, in practice, where we found most of the time, of course, we have unanimous decisions. But where we do have splits, it actually tends to be more philosophical. Sometimes we'll see our 2 former judges split out from the remainder. Sometimes we'll see other divisions, again, usually along kind of philosophical lines about, what they think the appropriate action should be. The staff itself, though, is required to be nonpartisan. So I'm nonpartisan, as well as our other staff here, our administrator. And again, we're a relatively small agency, just 6 staff and an IT contractor. We're required to be nonpartisan. And that's not just that, somehow being partisan would make you unable to do the job. It's that we want everyone to have trust that they can come to us, ask their questions, and get the right answer, get the correct answer according to the law. So we take that nonpartisanship very seriously. We also take confidentiality very seriously here at the commission. That's also in law. We've got some penalties under law, criminal, $10,000 fine, 9 months in jail if we ever breach our confidentiality here. So we take it very seriously. You can always feel free to contact us. Your requests for any sort of advice or guidance are protected. We were just talking about public records law a little bit ago. I can tell you that none of the records that are created pursuant to a request for guidance or advice, those do not get shared with anyone. We've got a specific exemption from the public records law for that sort of, for any of those records. So I mentioned we've got just a little bit of history I want to cover, and that's because if you look at some of our guidance, you look at some of our opinions, you'll notice that the names on these various records vary. You're going to see the Elections Board, you're going to see the Ethics Board, you might see the Government Accountability Board, and that's because the name of the agencies responsible for ethics and lobbying guidance over the years have changed. So the Elections Board had campaign finance and elections back in the 70s. The Ethics Board had lobbying and ethics. Those all got merged into the Government Accountability Board in the mid-2000s. And after the Government Accountability Board was split up in 2016, it got split into, again, elections and ethics. However, now campaign finance is kind of traversed from elections over to ethics. So now we have campaign finance, lobbying, and the code of ethics. So we do a little bit more elections work than we used to, but we've been doing lobbying and code of ethics. And a lot of this is the same staff. So you've got that institutional knowledge, you've got quite a long series of precedent, opinion precedent going back a number of years. And that's very helpful to us. You're getting the same answer that people before you got. Obviously, there's always new questions, there's new technologies, which tend to make life interesting for lawyers who are, the law doesn't answer that particular question. It doesn't even anticipate that particular question. But yeah, that's where we step in as staff and as the commission to review those laws and give people advisory opinions and guidance so that they can act consistent with those laws. And that's a big part of our responsibilities at the commission, is to go out and conduct programs, training programs, explain and interpret these laws, and then make any information that's filed with us public so that everyone can have some confidence in the decision-making of our elected officials by seeing that they are being compliant with the ethics laws. Within our jurisdiction, you'll see that there's been a somewhat division of labor here. The Ethics Commission, or the state regulatory agency, we handle the ethics of legislators, all the various executive branch agencies. We also handle the registration and reporting for our lobbyists and our lobbying principals. And then, as I mentioned, for campaign finance, we handle most of the campaign committees. But DAs will sometimes step in for ethics violations of local officials. So, your mayors, your city council people, school boards, et cetera. And they'll also sometimes handle those local campaign finance issues. But most of the time, you can always rest assured that any sort of advice or complaint is probably going to be handled by the Ethics Commission. So what we're going to cover today is we're going to cover the lobbying laws, just one major prohibition within the lobbying law itself, the prohibition on accepting anything of value from a lobbyist or a lobbying principal. And then we're going to walk through the various provisions in the Code of Ethics. And as you can see here on the slide, it covers a variety of different things, from use of office to accepting various gifts, using confidential information, conflicts of interest, and financial disclosure. So I'm going to start with the lobbying laws. The lobbying laws in Wisconsin are the most strict. They are probably the clearest black and white rules we have in the ethics context. But before we get into that, just briefly, again, I like to share these old cartoons. You can see this is, again, something that was kind of making fun of, in this case, the legislators at the Capitol, because there had been kind of this report about how legislators referred to lobbyists as angels because they were taking care of them, specifically taking them out for dinner, drinks, parties, things like that. So while all of you on various agency boards or commissions, you're maybe not getting wined and dined quite as much as a state legislator would, it's still important to be aware of the fact that you're in a public position. People may be aware of the fact that you have this role, and they may be looking to ingratiate themselves to you. So just be watchful for individuals that are, suddenly inviting you out or offering you gifts or extending invitations, things that you hadn't seen in the past. You just want to be watchful for that sort of thing. So the first question that comes up in the lobbying law is, who does it actually apply to? So it applies to all lobbyists in the state of Wisconsin. It also applies to lobbying principals being those organizations that employ a lobbyist. And you can find out who these individuals and organizations are at our website, lobbying.wi.gov. You can search by the name of a lobbyist or an organization. You can search by types of organizations, and you can also do keyword searches. So you can look for people in your particular area. If you're, licensing and regulation for a particular field, say, chiropractors or something like that, you can quickly just type that in, see all the lobbying, or all the lobbyists, all the lobbying principals who are working in that particular area. You can also download directories if you want to have that available to you. Sometimes that can be useful if you're going to be sending out some sort of communication or solicitation, and you want to make sure that you're not soliciting a lobbyist to provide something that they can't give. You can, match your mailing list against a directory. That can sometimes be useful. And then lastly, the lobbying website does provide some ability to track lobbying on rules or budget bill subjects or legislative proposals. So this might be something that staff are going to be doing on your behalf. But if you have a personal interest or you want to follow these things yourself, you can use the lobbying.wi.gov website to see who is actually making lobbying communications, what they've said, if they've got a particular position, yay or nay on a particular issue. You can all see that on the lobbying website. A couple other definitions that are important. Who's an agency official? So I'm presuming, or at least I'm going to talk today as if everyone in this call is an agency official. But this is something you want to check with your legal counsel for your particular board or commission. An agency official would be a member of that agency who, as part of their official responsibilities, participates in administrative action in more than a clerical, secretarial, or ministerial capacity. So they've got some sort of influence or control over the process. But it is a pretty broad definition. And the other thing that I want to highlight here is that it talks about, as part of their official responsibilities, they participate in administrative action. So it doesn't really matter if you personally have participated in this administrative action yourself. It's asking, does your position as a board member, do you have some sort of role in this administrative action process? And when we say administrative action, we're talking about administrative rules. So anything in the proposal drafting, development, recommendation, consideration, those sorts of things. So even if your organization may not have the ultimate decision-making authority on a rule, if you're proposing things or recommending things, you're probably still involved in administrative action. But again, that's something you want to talk to your agency's legal counsel about to determine if you are covered as an agency official. If you are an agency official, then this prohibition in the lobbying law comes into place, and that's a pretty broad one. No lobbyist or lobbying principal can give to an agency official lodging, transportation, food, meals, or beverage, money, or any other thing of pecuniary value. So that last catchphrase really just catches so much. Anything of pecuniary value, and pecuniary, financial, anything monetary, anything really that you would pay money for, you cannot accept. We call Wisconsin a no cup of coffee state because literally it means if they're a lobbyist and you're an agency official, you cannot even accept a cup of coffee from these individuals, unless an exception applies, and we'll talk about that in a second. But there's a real strict black and white line here that if that person is a lobbyist or an organization is a principal, you really need to be careful about what you would be accepting from that individual or organization, because unless it meets one of those exceptions, you're potentially violating the lobbying laws here. So there are a number of notable exceptions. First off is actual and reasonable expenses for presenting a talk or participating in a meeting. We encourage in our laws and the commissioners through their guidance and opinions, we encourage officials to go out and talk to members of the public, talk to organizations. We want you out there communicating about the business of your agency. That's fine. So you can accept any expenses that you might incur personally to go to a meeting, to present, be at a conference or something like that, where you're going to be talking about your agency's business. What you cannot accept, however, though, is compensation. So the actual expenses that you're out of pocket for, that you can accept. Compensation, anything above and beyond those actual and reasonable expenses, unfortunately, that's where the line is drawn with lobbyists and lobbying principals, because it just gets into a question of, well, what is reasonable compensation? So the legislature has drawn the line here with just expenses. New to the lobbying law, there is now an explicit, this used to be covered through our advisory opinion precedent, but now there's actually statutory authority that says you can accept admission to events, again, as long as you're discussing official business of the agency. So you can accept that without paying. So if they offer like a free admission to come and speak at their event, that's fine. However, if there was something included as far as food or beverage with the price of admission, you cannot accept that food or beverage without paying the actual cost of that. So usually lobbyists and lobbying principals, they're going to be aware of these restrictions. They're going to put something in their invitation saying, you can attend for free. If you wish to stay for the dinner or lunch or whatever it is that might be coincidental with the event itself, then the actual cost is $20 or whatever the cost is, and you would pay that separately. Third exception here is for items and services that are being made available to the general public. That kind of, we'll talk about the ethics code in a little bit, but there's a similar exception in the ethics code that says that you can accept things that are not offered to you because of your public office, because you're holding public office. And so this is kind of a similar exception in the lobbying law. If something is being offered to the general public, you can accept it on the same terms as a member of the public could. So you may see lobbying organizations, lobbying principals, commonly very large organizations, large businesses. And so they're going to be advertising, they may have a special offer or something like that, sign up for an account with the bank and get, $20, $50 or something like that. For maintaining a certain account. As long as those terms are available to people in the general public, you can accept it on those same terms. Other things you can accept from lobbyists and lobbying principals: education and informational material. A lot of times what lobbyists and principals are trying to do, they're trying to educate, they're trying to influence through information. And that's fine. That's why they register. That's why they go through this process, is so that they can do this process of talking to elected officials or appointed officials and trying to get them to see things their way or the way of their clients. And so as long as it falls into the realm of information, they're providing some sort of information or education opportunity, those are generally going to be accepted. As far as materials, again, if they're inviting you to a conference in Las Vegas or something like that to learn about their industry, that's going to be something possibly a little bit different. But if they're just providing you a book or a video or materials in some way, that's generally acceptable. This next exception, probably a good one for a lot of you who are serving on boards or committees or councils. So you can accept compensation if you're employed by a lobbying principal. And I know that's common for a lot of our boards and commissions. They're actually required to have licensed practitioners of whatever industry they're regulating. They're required to have them on the board. And so a lot of times those individuals will themselves be employees of lobbying principals. So this exception specifically says that you can continue to accept compensation from your employer as long as you are an agency official solely because of your membership on that state commission, board, or council, and you're not receiving compensation from the state other than a per diem or reimbursement of your expenses. But it's important to note that your compensation for your employment shouldn't magically change because you've joined a state board or council. So your compensation can't exceed which is paid to those that are in a similar situation, similar circumstances. And you'll note here, other exceptions may apply. The lobbying law has a bunch of very narrow, very corner case type exceptions. And so whenever you're presented with a situation that involves a lobbyist or a lobbying principal, I, again, encourage you to talk to your agency's legal counsel, contact the commission to run it by them to see if there's any other exceptions that may apply or any other prohibitions you may need to be aware of. Because this is a very tricky area. And again, it's very black and white. If there's not a specific exception that applies, it tends to be a violation. So you just want to be very careful when you're accepting anything from a lobbyist or a principal. There is something that is a little bit more open here, and that is campaign contributions. So a lobbyist, while they can't personally reach into their own wallet or purse and give you a contribution if you're running for office, they can deliver a contribution from an organization like a PAC. And so you'll see lobbyists that may represent a particular industry. That industry has a PAC. They can also be working with the PAC and they can be providing contributions through that PAC. That's fine. It's just those personal contributions that are restricted. And again, the personal contributions are only restricted until we get up to what we call the window. It's essentially the election period. So your first day to circulate nomination papers through the date of an election, even a lobbyist can provide a personal contribution at that point. So just be aware of that. I don't know how many of you may be elected or serving in an elected role, maybe at the local level, but you just want to be aware of this, this restriction that can apply as well. A little bit broader than the general lobbying law, but still something worth being aware of. Okay. So that's the major prohibition of the lobbying law. Like I said, feel free to contact us if you have a situation that arises, but I'm going to want to spend the majority of our time here on the Code of Ethics. So first thing with the Code of Ethics, again, this applies to people holding state public office. I presume, again, most of you are going to be covered as state public officials, but as you can see on the slide here, there's a variety of different offices that are included. I think it's also useful to know that this is not some special rule that only applies to you. This applies to the governor on down as far as our elected and appointed officials. We are holding everyone to the same standards. A couple other definitions. So you'll see when we get to the ethics code that it applies not just to things that you personally receive, but also things that your immediate family receives or may be a benefit to your immediate family. And so it's important to note that immediate family is not what you might expect if you just looked at a dictionary. Immediate family under the ethics code is only an individual's spouse or an individual's relative by marriage, lineal descent, or adoption who is receiving more than 50% of their financial support from the official, or vice versa, the official is receiving more of 50% of their financial support from this individual, this relative. So we get questions all the time. You know, an official has an adult child. They have their own household. You know, but they're taking official action that somehow impacts that adult child. Is it something that they may want to avoid due to the appearance of bias? Yes. Is it something that is prohibited under the Code of Ethics under the state law? No. Because again, that person is not immediate family, and so they are not covered. If there was some sort of secondary benefit to the official, then maybe. But generally speaking, if they're in their own household, they're not financially dependent, or they're not financially providing for the official, they're not going to qualify as immediate family here. And then the third category of people, so you've got the official themselves, their immediate family. The third category of individuals that the Ethics Code tends to look at is organizations that are associated with the official. And again, associated, it sounds like a broad term, but we've got a specific statutory definition here. And so you're only associated with an organization if you're an officer, director, or trustee. So you're on that controlling board. If you own or control at least 10% of the outstanding equity of the organization, so you've got that ownership stake of 10% or more, or if you're an authorized representative or agent. And that's going to be very fact specific. If you've actually been authorized by that organization to represent them in some way, you may be associated with that organization. It's important to note that organizations with which you're associated is something that is also going to be disclosed later on when we talk about financial disclosures. So you'll see this again. Organizations do not include bodies politic. So if, again, you're on a school board, you're on a county board, something like that, you don't need to worry about the potential interactions of your state role with your local elected role, because, again, organization doesn't include bodies politics. So you can take action as a state official without worrying about how it's impacting local governments, at least under the ethics code, I should say. And then lastly, anything of value. And it's kind of like how we had pecuniary value in the lobbying law context, we've got anything of value here in the ethics context. This is a very broad term. Any money, property, favor, service, payment, including, not limited to, a promise of future employment. So this covers a real broad swath of things that could potentially come up. But again, there are exceptions. It does not include compensation or expenses paid for by the state, political contributions, hospitality, except for a purpose unrelated to state business. So again, we'll talk about the exceptions in more detail a little bit later, but when we're talking about anything of value, it specifically does exclude hospitality. If you're at somebody's home, you don't have to worry about, the drink that's being poured for you at somebody's house, a meal that might be provided, something like that. All right, so the first of the prohibitions within the Code of Ethics says, again, quite broadly, the state public official may not use his or her public position or office to obtain financial gain or anything of substantial value for the private benefit of themselves, their immediate family, or an organization with which they're associated. So you can see all those definitions we just talked about and how those play in here. Again, exceptions, campaign contributions, and there's also an exception here for candidates. So candidates, when that term is used, it actually includes both people that hold office, elected office, as well as people who are seeking elected office. So it's covering both sides of that. Those individuals may solicit for donations to nonprofits, even if they're associated with them. So there's an exception for nonprofits in that limited capacity as well. But you can see how this is a very broad prohibition. And it's getting to what you can commonly understand as something that would be an ethical concern, a use of governmental authority in a way to privately benefit yourself, privately enrich yourself, your family, or an organization with which you're associated, like a business that you own or have an ownership stake in. And this does come up from time to time. I try to draw examples from years ago so as to not embarrass anyone that might currently be in state service still, but this is an article from 1990s. You can see there was an agency official who had been buying travel tickets, airline tickets through his wife's travel agency. Not necessarily anything that was wrong as far as the amounts that were paid. It's not like he was vastly overpaying for these travel arrangements, but he had used his office to direct that they use this particular travel agency for his travel. Or in one case, I think he had booked the travel himself. That was a use of office that privately benefited his spouse, because the spouse was a travel agent, got a commission off of the deal. So that is just one example of how these things can potentially come up in your day-to-day government roles. Another example here, and a common question we get is, I have a number of friends and they invited me out. So we'll say a Brewers game in this example. Sometimes it might be someone who is affiliated with a lobbying principal and they've got a skybox or premium seats in some way. Can I accept a ticket in those circumstances if they're an old friend? Well, the guidelines for accepting gifts really should, these are what we highlight for you. Don't accept anything from a lobbyist or lobbying principal, even if you pay for it, unless you're sure a specific exception applies. So again, if in that context, if the old friend is a lobbyist, you're probably not going to be able to accept. There's very few exceptions that would apply in that context. Lobbying principal, there might be slightly more, but unlikely that you're going to be speaking on behalf of the agency or on behalf of the board while you're watching a Brewers game in a skybox or something like that. So probably not going to qualify to some of the exceptions there either. So again, when we're in that lobbying area, it needs to meet both an exception to the lobbying law as well as an exception to the ethics code. So you have to meet both standards. Now, let's take the lobbying law off the table for a second. Let's say that the old friend is not in any way a lobbyist, lobbying principal. You're just looking at the ethics code. We would still say, don't accept any item or service of more than trivial value if it's being offered because of your position. If you've got that prior history, it's a friendship, longstanding over a number of years, you might have reason to believe that it's not because of your official position, that's fine. But again, if suddenly you're getting offers to attend events for free that you were not being offered before, you might want to be skeptical or a little bit suspect of such offers. Again, if anything is being offered for reasons unrelated to your public office, there's a birthday, there's a wedding or something like that, generally under the ethics code, again, you can accept these sort of things as long as the reason that is offered is unrelated to your public office. If there's an offer to the general public, again, you can accept that on the same terms. But it's important to remember that where you are accepting gifts, you have to disclose on your statement of economic interest. That's the financial disclosure form we'll talk about later. If you're accepting gifts, you need to disclose on your SEI the identity of any individual or organization who gives you gifts valued at $50 or more in the aggregate in the calendar year. And so a couple of things can trip people up there. First off, the aggregate. You see a person, they take you out to dinner a couple times. It wasn't $50 on any one occasion, but over the course of a calendar year, it adds up to that amount. They need to be disclosed. The other thing to be watchful for is the fact that the face value is not always the true value. So when you're reporting something on your SEI, it's gifts of $50 or more, that's the actual value. So there might be a ticket, for example, where the actual or the printed value on the ticket is $20, $25, something like that. But if you looked on StubHub or Ticketmaster or something like that, trying to buy that ticket yourself, you may find that it's significantly more than that printed value. So you always want to be watchful, again, when you're receiving gifts and you're thinking, oh, it's a trivial amount, I don't need to worry about reporting it. Particularly with things like tickets, I encourage you to do your research, make sure that you know what the market value is of what you're accepting so that you can be confident as to whether or not that person needs to be disclosed. If you find that there is a gift that has been offered, or in this case where you've received it and you can accept it, the statute provides for a variety of different ways that you can dispose of that impermissible gift. You can give the item to your agency if it's something that the agency would use or potentially be able to sell. It's important to note, though, that the agency can't then turn around and sell the item back to the government employee or official. If it's something that another state agency or public institution could use, you can donate it to them. You can give the item to charity, although not one with which the official or their family is associated. Again, we want to steer clear of any even perception that you're somehow using your government position to benefit yourself or your family. The unpopular answer sometimes is to just return the item or the gift. I often encourage people in these situations, feel free to use the Ethics Commission as the bad guy. We're the mean parent. So, you can say, I contacted the Ethics Commission, or I looked at the Ethics Commission's guidance. This is not something I would be able to accept. I'm sorry, please accept it. I'm returning it to you, etc. The last option here, so if the donor is not a lobbyist, or if it's an organization that's not an organization that employs a lobbyist, you do have the option to purchase the item and retain it, even though it may be otherwise impermissible, as long as you've made that fair market exchange to obtain the item for its fair market value. Then essentially we would be saying under the ethics code, you're not getting any benefit from using your public office. You're paying the same amount that any other person would pay. That can sometimes work out in situations where it's things like a t-shirt or a hat, where an organization might sell something. And you can see on their website exactly what the cost of that item is. And so you could pay for it. But again, when you're talking about admission to an event or tickets to an event, sometimes it can be very tricky to figure out what the actual value is that you would need to pay to purchase. And so I do discourage that, unless, again, you've been in consultation with agency legal counsel or with the Ethics Commission, so that you feel that you've got a strong enough basis to accept under this exception. The next prohibition here, influence and reward. So we want to prohibit state public officials from accepting things that could reasonably put their judgment in question. So again, the prohibition is that a person can't give and an official cannot accept, cannot solicit or accept anything of value that could reasonably be expected to influence their official vote, actions, or judgment, or could reasonably be considered a reward for official actions or inactions on part of the official. So this is one of the prohibitions that comes into play a lot when we're talking about accepting things, and is the basis for our general rule of thumb that you should not accept things of more than nominal value, particularly from organizations that have a special or specific interest in any item or matter that's going to come before you or your agency. So you know your agencies and who the major players are, who the frequent flyers are, perhaps for your agency or board. So be watchful, again, for things that you're receiving from those individuals or that they may be offering, because it could, you may not be influenced, you personally may not be influenced, but you could see how a member of the public could reasonably be expected to say, oh, well, they received, something from this organization, how could they possibly be impartial? So you just want to play it very safe, very cautious when you're accepting things of value, particularly from those organizations that are going to appear before you. One thing I'll note here, we do have a line of opinion precedent that talks about awards. And I know a lot of you, again, are in boards and councils, commissions that may be regulating a particular profession. And so sometimes we'll get questions about, well, I was named, practitioner of the year or something like that by the association that advocates for this particular profession. Can I accept that award? The commission's precedent, and again, this goes back a number of years, says that an award, as long as it is something like a plaque on unremarkable or not particularly valuable material, so like wood, plastic, something like that, the awards, once inscribed, really don't have any financial value. There's no pecuniary value there. So we would not say it's anything of value, and so it wouldn't be prohibited under the ethics laws. There may be some prestige associated with being named, practitioner of the year, but that's kind of a speculative benefit. The ethics code really does focus more on the demonstrable financial benefits that are being conveyed to an official because of their role. So something like a person of the year or a practitioner of the year. Certainly there is some prestige value, there's some intangible benefit to being named for those sorts of awards, but not anything that we've ever found to be raised to the level where it presents a conflict of interest. So you can still accept those sort of awards. Again, as long as they're inscribed on unremarkable materials. Certainly, we've seen situations where an organization tries to present something that's, a $400 crystal vase or something like that. It's not inscribed, it's just being given in recognition of, lifetime achievement or something like that. That's probably not going to be acceptable because that has a direct pecuniary value. It's not inscribed. The official could very well sell that and, recoup some of that value. So again, you got to be watchful for the specific facts of what the award is and what you'd be receiving. So another question that comes up sometimes in this influence and reward context is being invited to teach a class or a seminar. Typically you're serving on these boards, you've got some expertise, you're maybe at the top of your profession. Can you go back to your college, the school where you graduated and teach a class or a seminar? Maybe they even are offering direct compensation for that. Again, the ethics code does not want to be a barrier to you going out and talking to students or anyone else about the business of state government, the boards and commissions that you're on. You may even accept reasonable compensation. We do caution people, however, though, you must prepare or present whatever it is, the class or the seminar, without more than incidental reliance on state resources. So if you're drawing on the materials provided to you because you're a state official, work that may have been done by staff at the agency, slideshows that are put together by the agency, not put together by yourself personally, you shouldn't be accepting compensation for those sorts of presentations, because really that's rewarding you for something that the state provided to you. And again, you still can't accept anything from a lobbyist or lobbying principal unless there was some other exception that applies. So while you might not realize it, a lot of the universities in the state are lobbying principals. And so if you're being invited, you always want to double check that lobbying.wi.gov website, make sure that the organization isn't a lobbying principal. But assuming they're not, you can accept compensation, which can include things more than money. It could include things like gifts, entertainment, travel, and that could include both yourself as well as a spouse or other family. So compensation is permitted. Just again, be aware when you're receiving compensation and you're going to have that financial disclosure once a year, the threshold here is $1,000. So if you receive more than $1,000 or $1,000 or more, I should say, in a calendar year, you need to identify them on your financial disclosure statement, your SEI. Third prohibition here, food, beverage, travel, and lodging. This is kind of more specific to those categories of things that you might receive. And there's a variety of exceptions here. The big ones, again, official talk or meeting. If you're going to an official meeting or you're presenting an official talk on behalf of your agency, generally speaking, you can accept any food or beverage that's provided coincidental with that meeting or talk. But it's important to note that you do have to be actually presenting or talking at this meeting. Just going to events that are social in nature, you're not actually on the agenda for a presentation or something like that, that's probably not going to qualify for this particular exception. You do need to have some sort of role where you're speaking to an audience. Other exceptions, again, that unrelated to holding public office is fine. There is a specific exception here. It's called the state benefit exception. This often comes up in the educational or informational context. So maybe there is a national conference that handles your particular area of expertise. An organization offers to pay for you to travel to this conference and attend this conference. Again, this is something you'll want to run by your legal counsels, but generally speaking, if the primary beneficiary of the travel is going to be to the benefit of the state and having more informed decision makers, then we would say that you can still accept. But again, that is only under the ethics code. If the lobbying law applies, you'd have to find another exception. Political contributions and expenses by political committees. You can also accept those, as well as anything offered by WEDC and the Department of Tourism. They have their own special exceptions under the ethics laws so that they can do their work, either promoting economic activity in the state or promoting tourism. And here we've got a guideline, it's guideline 1211. And this guideline was written specifically from the perspective of, if you're being offered something, can you accept? So I encourage you to look at this guideline. The materials will be provided after the presentation, but you can find it on our ethics website, or if you're looking at these materials later, you can click on this link in the PDF and it'll take you to that guideline and it'll walk you through the various exceptions. Another prohibition here, use of confidential information. I don't know how much this will come up in all your various roles, but it's important to note that if you are in the know about things that have not been released to the public, so either it is confidential, so it's not going to be disclosed, or it simply has not been disclosed yet to the public, you cannot be using that information or disclosing it to another. And note that this goes beyond just the immediate family. This includes any other person. You can't use that information to benefit yourself, your family, or any other person if it has not been communicated to the public or is not public information. So, say you know that DNR is going to be more heavily regulating a particular pesticide or some other chemical. It's going to hurt the stock price for a particular company. You can't be, telling your friend, even though they're not related to you, that they should be dumping that stock, for example. All right, and then the last prohibition within the actual code of ethics is the unlawful benefit prohibition. Kind of nebulous, but you can see here from the picture, this is where it most commonly comes up. Somebody gets pulled over. They say, don't you know who I am? Or, hey, officer, can't you give me a break? I'm, such and such state official. That would be an attempt to use your office to gain an unlawful benefit. And so that would be prohibited. And again, this extends not just to yourself, but to others. So you can't be throwing your weight around to help out other individuals, even if they're not related to you, at least where it's an unlawful benefit. And then we also have a body of opinion precedent that talks about conflicts of interest. There's a separate statute within the Code of Ethics that talks about conflicts of interest. It's got two different prongs to it. First, you cannot, as a state public official, take an official action that would substantially affect a matter in which you, your immediate family, or an organization with which you're associated has a substantial financial interest. So that's kind of a fact-intensive question. Did the action you take substantially affect the matter? Did they have a substantial financial interest? Those are going to be pretty fact-intensive questions. The second one, though, you'll see kind of relates back to the Code of Ethics we talked about before. You cannot use your office or position in such a way as to produce or assist in the production of a substantial benefit. So note there's a difference there. Under the Code of Ethics, it was anything of value. Here, it's produce or assist in the production of a substantial benefit. Again, for the official, a member of their immediate family, or an organization with which they are associated. So this is a potentially broader prohibition. So when you're talking about a conflict of interest, you want to be, again, very cautious. So there are some exceptions here. So first off, the Code of Ethics is not supposed to be preventing state public officials from engaging in otherwise lawful activity. So, we recognize, particularly for members of boards and commissions, this is probably not your full-time job. You've got something else you need to be doing as far as employment or some sort of association or organization with other members of your profession. So we don't want the Code of Ethics to prevent you from serving on a board because we want your expertise. We want your perspective on these boards and commissions. We know that you're going to have some sort of economic interest at times in the decisions that are being made, and that's fine. You retain those rights to have a private interest in these matters, both personal and economic. But you need to be able to make those decisions in a way that is going to be unbiased, nonpartisan, taking into account the good of all parties involved. So there is this clear line in the opinion precedent and in state law that says, yes, you can have these interests, but you still have to operate in a way that doesn't interfere with the full and faithful discharge of your duties as a state public official. What the Ethics Commission and its predecessors have done is we've developed a test here, and again, it's a 3-part test. An official may act even if they have a conflict of interest, as long as the official action in question is going to affect a whole class of similarly situated interests. The official's interests, or the family member or the business or organization, their interest is not significant when compared to all the other affected interests in the class. And the action, the effect of the action on those interests is not disproportionate. So it doesn't treat the official's interests any better or any worse than any other member of the class. And again, we've got another guideline here that kind of talks through how you conduct this analysis. But again, this is, again, something where if you think, hey, this action is going to affect my business, this action is going to affect me personally as a profession or a practitioner, you can kind of think through this analysis. Is it something that's going to affect all people in my practice, just people in my particular area of expertise? How narrow is that class? How is the decision that's going to be made? Is that going to have a disproportionate impact? These are the things that you can talk through with, again, the agency legal counsel or with the commission. Also, there are another couple exceptions here. If an official action is regarding the lawful payment of salary or benefits to an individual or reimbursement of expenses, that's allowed. Modification of municipal and county ordinances are allowed. And then lastly, conflicts of interest should not be speculative. We are always looking for, is there a direct and demonstrable result of the official action that benefited the official? If the action that is taken is, well, it might benefit them at some point in the future, we don't know, that's typically not going to be sufficient to require an official to recuse under the conflict of interest provisions in state code of ethics. It may still be a good idea for an appearance of impartiality, avoid that appearance of bias, but is it required under state law? Not necessarily. But again, these are things that you want to have these conversations up front. You don't want to have the discussion in your meeting and then go to your agency legal counsel afterwards like, oh, I participated in that discussion, but I think I might have a conflict here. You want to be looking at your materials, look at the agendas for your meetings ahead of time so that you can flag these issues for your agency legal counsel ahead of time, and they can give you some advice as to whether or not you need to abstain from participation. The last thing I wanted to talk about briefly was statements of economic interest. I've mentioned these throughout the presentation. It's an annual requirement for not all, but I would say most individuals who are serving on boards and councils. Again, your agencies will be able to tell you if you're required to file the statement of economic interest, but I would assume generally most of you are. It requires you to identify your sources of income, your investments, your real estate, creditors, etc. New though, we have changed, the legislature changed some of the definitions here. So we used to have to report things like defined benefit plans, annuities, and money market funds, mutual funds. Those things have all now been excluded from the definition of security. So those are not required to be reported anymore. But so it got a little easier to report. But then also, if you ever leave your position, it's important to note that you do have to file what's called a final SCI within 21 days of leaving your position. It used to be that, if you served even a few days of the calendar year, we wouldn't necessarily get the SCI from you right away, but we would be looking for it later in the year. And so what the law essentially did, the change to the law did, is it just moved up the requirement from mid-year, when most people are filing their SCIs, to 21 days after leaving your position. A little bit easier to get a hold of people when we make that deadline a little closer to actually leaving office. But just keep that in mind. You're going to be filing these SCIs. If you ever leave, you'll have to file one last one on your way out. Also, I encourage you to use the SCI process. So again, you're going to be listing where you're getting income from. You're going to be listing where any creditors are, who they are. You're going to list those organizations that you're associated with, so businesses that you have an ownership stake in. These things are all going to be disclosed on your SCI. So use that as a way for yourself to identify, okay, with these particular organizations, I need to be more careful when I'm going to be engaging in official action that might impact them. It's a way for you to kind of go through this process once a year, figure out who are the people I need to be cautious regarding. And again, you can use that in your conversations with the agency counsel if necessary. So with that, I've got, I think, a few minutes left for questions. I don't know if we have any, but thank you for your time.
And thank you, Attorney Berger. We do have a few questions. Some of them are multi-part, so I'll go through those one by one. The first question we have comes from Carl Linick from the Professional Engineering section of our AE Joint Examining Board. His question is, does the lobbying law prevent a board member from discussing issues with the legislature? Can a board give an opinion or pros and cons to the appropriate legislative committee?
Yes, you can still communicate with the legislature. There's actually exceptions in the lobbying law that provides for state agencies specifically to designate individuals or officials that will be liaising with legislative members. So you've got that exception. Also, there's an exception in the lobbying law for any requests from legislators or legislative officials, so staff members. If they've requested information, you can always respond.
Okay, and does the general welfare of the state wording in Wisconsin statute 15.08 sub 6 allow for any contact with the legislature?
Again, I think contact with the legislature, if you're designated as one of those legislative liaisons or you're working with someone with your agency who's a legislative liaison, that's generally going to be accepted under the lobbying law. I'm not familiar with that specific language that you're talking about in chapter 15, but generally speaking, there's the only people that are prohibited from, well, I shouldn't say prohibited, but the only people that are regulated from engaging in lobbying activity are those individuals who are being paid on behalf of an organization to represent their interests before the legislature. So it's not going to commonly apply to a lot of folks who are either contacting legislature on their own, in their individual capacity, or even in their professional capacity, as long as they're not being paid to specifically go influence the legislature.
Okay, and so this is still in the same vein, but if there are portions of the statutes which contain wordings that are, say, archaic or obsolete, can Carl, as a board member, go directly to the proper legislative committee to suggest the change of wording, or should he be going as a citizen of Wisconsin?
I would probably want to, you'd probably want to talk to your agency legal counsel before going on behalf of the agency. Even if you're the chair, I think it makes sense to run that by agency counsel just to make sure. Certainly if you're going in your own individual capacity, there's, again, the lobbying law does not apply to individuals that are operating in their own individual capacity who are not being paid by any other person.
Okay, thank you. We'll move on to our next question requester, which comes from James Gersich of the architect section of the AE Joint Examining Board. This question is, does the exemption under Wisconsin statute 11.0206 only apply to candidates? And this is when we were talking about Wisconsin statute 19.5. Yep.
Yeah, so if you have a cynical view of government, you might say, yeah, it's a little suspicious how that exception was drawn. It is specific to candidates, but again, candidates covers both people who currently hold elected office as well as people who are seeking elected office currently. So they can solicit on behalf of nonprofits, but just regular state public officials, if you're not a candidate, no, you cannot solicit for a nonprofit that you're associated with, no matter how good the cause.
Okay, I think we might have a couple more questions that are coming in. Let's see. Another question is coming from Melissa Blake. Sorry, Melissa, I didn't have time to look up your board, but being asked, she's being asked by a local technical college to consult on the development of an aesthetics program and to be a member of the advisory board. Would that be an issue?
So the local technical college, I'm assuming is part of the Wisconsin Technical College system. They're going to be an organization of the state. So they're going to have that same legislative liaison exception that applies in the lobbying laws. I don't think that any action you're going to take or anything you might be accepting from them to serve on their advisory board would implicate the lobbying laws, but it's good to be watchful. And certainly as you get more details about that, again, something I would run by your legal counsel.
Okay, and then another question came in. What is your responsibility if an immediate family member tries to use your position for their benefit? For example, your wife gets pulled over and says, "Do you know who my husband is?" and tries to get out of a ticket.
So the ethics code, for good or ill, only applies to you as a state public official. It does not apply to the spouse. Now, again, that's certainly something you might want to have a conversation with that spouse about, but it's in that situation that you're describing, no one has violated the ethics code because the spouse is not a state public official.
If we have future questions, who can we ask regarding specific scenarios in the future?
I think your first point of contact would be whoever your agency designated legal counsel is, because they're going to be familiar with the particular official actions that you might be facing at a coming meeting or something like that. But certainly you can always talk to us here at the Ethics Commission. You can reach out to me directly. We've got a very small office here. If you pick up the phone, call our office and say, I want to talk to David, I'm the only person here. So feel free to do so. I'm happy to respond to emails or phone calls, help you work through the situation however we need.
Thank you, David. Thank you, everyone.